Yes.
Now, the allegation against me is that on May 28, 2020, I have sent 24 emails from my official email ID to my personal email ID that contained company confidential documents. Almost 4 months later, a complaint is filed alleging offenses under the IT Act, sections 66, 66C, 72A, and also cheating.
Data theft is the allegation?
Yes.
All right.
The reason is the plaint is filed after the complaint. They don't disclose in the plaint that these have not been forwarded to anyone and that there were don't deleted emails. Notwithstanding all this, these stigmatic allegations are made to make out the offense of cheating. And also that for the same set of facts and circumstances, both cheating and criminal breach of trust cannot be made out.
Correct.
Here, to make out cheating, they have imputed that, I joined with the intention of teaching, which is not the case. And these are stigmatic allegations. I am not confronted with any evidence to show that I have misappropriated or I have stolen data. If my lord has made up his mind, then I will.
Made up, illa, sir. Don't give these old style arguments. If my lords have made up my mind, I will not submit. We are in a dialogue.
Mere transferring the confidential data of another person or company without their permission itself amounts to an offense under the Information Technology Act 2000. This is the finding. 66C. That is for identity theft. I have not stolen anybody's identity. So if they had this whatever evidence against me, they could have filed it along with the complaint. They need not have waited for 2.5 years to go and give it to the police.
Yes, sir.
Petition has been preferred on 2 grounds, my lords. One, initiation of criminal proceedings is an abuse of process of law.
Yes,
second is flaws in the order of cognizance, calling for interference by his honorable court.
Yes.
Now, the allegation against me is that on May 28, 2020, I have sent 24 emails from my official email ID to my personal email ID that contained company confidential documents and which was discovered the next day, May 29, 2020. Now, on May 29, 2020, I have voluntarily handed over my personal laptop, my mobile phone, and my Google Mail credentials to prove my bona fides. Now, after this, on September 24th, 2020, almost 4 months later, a complaint is filed alleging offenses under the IT Act, sections 66, 66C, 72A, and also cheating. Now, no preliminary inquiry is done. FIR is registered on the very same day.
Anyway, B report hakidrala, adake yaake hogtira?
B report has been rejected.
That is why. Why do you go before, travel back and say preliminary inquiry is not done? They filed a B report in favor. Yes.
Second, a civil suit is instituted on October 22nd. There is an order of injunction against me wherein I am restrained from disclosing company confidential material to any third parties. That is in force now. Now, civil suit was filed after the complaint has been filed. So, the basic premise would be that the allegations in the plaint and the complaint should be more or less the same. I will point out the embellishments that have been made in the complaint vis-a-vis the plaint to make out a complaint. Kindly come to page 158, my lords.
Data theft is the allegation?
Yes.
All right. 150?
158, my lords. This is the plaint.
Yes.
Para 4.17. On 9/7/2020, the KPMG gave its final report with detailed observations and the suggested course of action. In terms of the said final report, KPMG came to the conclusion that the defendant copied the 24 emails from the official email address to his personal email address. The said emails have not been forwarded and that there were no deleted emails. These findings were from the personal email address of the defendant. Yes. Kindly come to page 83, my lords. Para 6.
Yes.
It was also confirmed by KPMG that on May 28, 2020, 1 day prior to his resignation, Rahul Pandya had indeed sent 24 emails from his official so-and-so ID to a Gmail ID, as was also found by the company's internal team in the earlier. In the said batch of emails sent on May 28, 10 emails were from so-and-so and so-and-so. Here, they don't mention the fact that KPMG has also reported that these have not been forwarded to anyone and there are no deleted emails. Now, please come to page 87. So, this has been deliberately omitted in the plaint. Kindly come to page 87. Plaint in the civil suit.
Why are you on that?
The reason is the plaint is filed after the complaint. They don't disclose in the plaint that these have not been forwarded to anyone and that there were don't deleted emails. This is one.
All right. Copy paste madad bekagilla.
Right. Next. Para 10, your lord. On page 87. Fifth line.
Yes.
I'll read out. It is crystal clear that Rahul Pandya was not just cheating the company on almost a daily basis, but possibly also had fraudulent intentions to steal valuable confidential data / proprietary information of the company from day one and possibly even before joining the company. And prima facie appears that he joined the company only with the sole motive to commit the aforesaid offenses of criminal breach of trust and cheating, in addition to offenses committed under the Information Technology Act 2000. Now, illi Notwithstanding the fact that I've undergone a technical interview, cleared it, a HR interview, cleared it, a third party has been engaged to verify my educational credentials. Every company that I work for, the dates have been verified, reference checks have been done. Only after a clean sheet is given by the third party, only then an offer of employment has been made to me. Notwithstanding all this, these stigmatic allegations are made to make out the offense of cheating.
Idu Z-work complainant.
Huh?
Z-work is a complainant?
No.
Oh, because he... Yes, sir.
So these stigmatic allegations are made. Now, it is also and also in Delhi Race Club versus State of UP and others.
Sir, what is 406? What is 420?
Yes,
separate?
and also that for the same set of facts and circumstances, both cheating and criminal breach of trust cannot be made out.
Correct.
Here, to make out cheating, they have imputed that, I joined with the intention of teaching, which is not the case. And these are stigmatic allegations. Charge sheet hakila, B report hakudru.
B report hakadru.
Yeah.
Cognizance ಯಾವ್ದಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ?
66, 66C, 72A, and also 420.
All right.
I'll come to that also, my lords. Now, it is a civil dispute, is my contention.
ಅಲ್ಲ ಇದು ಆರ್ಡರ್ ಆನ್ ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
Order on B report either cognizance has been taken and it has been posted for sworn statement of the complainant.
How did you get to know?
Huh?
How did you get?
I filed an application under 452 seeking a return of my mobile phone, my laptop.
Oh, then you got to know.
Yes.
Yes.
Now, in between this 4 months, a disciplinary inquiry is also done.
Disciplinary inquiry?
Yes.
By whom?
By the complainant.
Samsung?
Yes.
Oh.
A show cause notice is issued to me.
ಅದರಲ್ಲಿ exonerate ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮನ್ನು?
ಇಲ್ಲ, ಹೇಳ್ತೀನಿ ಅದನ್ನು. Kindly come to page 133, my lords.
133? Where is the order on summons? Nothing.
Summons issue ಆಗಿಲ್ಲ.
Issue ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡಿ ಕೇಳೋಣ.
ಅಲ್ಲ, let me point out. Initiation of criminal proceeding itself is what I'm calling for interference, my lords.
ಈಗ B report is rejected and cognizance is taken. Anyway, it's not maintainable ಅಂತಲ್ಲ. It can. But let the court issue summons.
May I point out, my lord, that this is a civil dispute? Kindly come to page 133, my lords. The 5th paragraph. Accordingly, as a matter of natural justice, company hereby gives you a chance to present your narrative facts, etc., etc. In that same paragraph, it says, if in any case you have nothing to add or substantiate and you accept your fault, you may prefer a written apology and admission of fault by way of written communication addressed to the company within 3 working days. So, disciplinary inquiry show cause notice kottaga, I'm also offered the option of giving a written apology. I attend the disciplinary proceedings. I also give a written submission. Kindly come to page 144, my lords. This is the minutes of meeting of the disciplinary inquiry. In this, my lords, there are only 2 documents. One is the show cause notice. Second is the apology letter. I am not confronted with any evidence to show that I have misappropriated or I have stolen data.
You want me to give a finding on everything?
I mean, if my lords has made up his mind, then I will.
Made up illa, sir. Don't give these old style arguments. If my lords have made up my mind, I will not submit. We are in a dialogue. Yes.
Then can I come to page 71, my lords?
Yes, come. Yalla, if my lords have made up my mind, I will not submit further. All new judiciary, sir. Yes, come up with new things.
Page 71, my lords.
Yes.
This is the order of taking cognizance.
Page
71. Mere transferring the confidential data of another person or company without their permission itself amounts to an offense under the Information Technology Act 2000. This is the finding. Now, section 66, the first section that I'm charged with, it starts with if any person dishonestly or fraudulently sends information. So, intention is paramount here. Here it is held that, intention is not at all required. This one though. Section 66C. That is for identity theft. I have not stolen anybody's identity.
So now 66, 66C, 72A and 420.
Yes, 72A also, my lords, it is for breach of disclosure of information in breach of lawful contract. It is for between an intermediary or a service provider. It is not applicable to this case. And last is 420, wherein they have imputed intention to me even before I joined, wherein they have thoroughly verified my background. Only after that they have made an offer. Indeed, if they had this whatever evidence against me, they could have filed it along with the complaint. They need not have waited for 2.5 years to go and give it to the police. These are my points, my lords.
All right. Yes, sir.